Okay, so welcome everyone to our data breach claims webinar. I'll introduce myself. I'm Lisa Maynard and I'm a claims relationship consultant in Zurich. And I'm joined today by my colleague, Becky Sutton, who's a claims relationship manager. I'm really pleased to introduce our presenters for today. Starting off the webinar, we have Steve McGee, who is our technical claims manager at Zurich. And taking the second part of the webinar will be Beth Foster, who is one of our senior claims technicians. Okay, together, Steve and Beth are part of the specialist team here at Zurich, and they have a wealth of knowledge and experience in this area. So please, if you have any questions throughout the webinar, if you can pop them in the chat. There's a Q&A tab at the top of your screen. If you can pop any questions in there throughout, and then we'll have time at the end of the webinar to answer all of the questions. Okay, I think I've covered everything. So with that, I am going to hand over to Steve. Thank you.
Thank you, Lisa. Can I just check that the slides are showing for everyone?
We've got a thumbs up.
Okay, perfect. Okay, so thanks for the introduction, Lisa. As Lisa said, myself and my colleague Bethany will be talking through this presentation today, and it should last between 30 to 40 minutes, just depending on how it goes. Beth and I work in the specialist claims team, as Lisa said, and we deal with claims of this nature, as well as several other types of complex claims. So we'll just quickly cover off the agenda. The presentation today will be pretty fluid, but this shows the high-level topics that we'll be going through. So firstly, talking about the market in general, moving on to the Zurich experience and the reasons for the increase in volume over recent years. I'll briefly talk over the standard policy coverage under Zurich policies before Beth takes over and talks you through some typical claim scenarios and how they are assessed from both a liability, quantum and cost perspective, talking where she can from her own detailed experience where she's had a lot of success in various areas over the last couple of years in particular. So just let's start by looking first of all at the current environment. It feels like every other day at the moment there is news of a high-profile data breach in the headlines, and this slide details some breaches involving some very recognisable brands. Most of these examples involve cyber attacks by very sophisticated criminals, which is becoming a growing problem in its own right. But it shows that criminals do not discriminate in terms of who they target. Over the years, we've seen claims against public authorities, education providers and charities. So, as I said, every policyholder and customer is really open to attack here. Whilst the main theme of this presentation will not be on claims arising from cyber attacks, the prevalence of this as an issue in the public eye at the moment makes it a pretty ripe area for the claimant representative community. We're always looking for their next revenue stream. We'll talk a bit more about that in due course. It's become apparent in recent times that this is certainly an area that's been targeted, as we'll see on the next slide when we look at the development of the claims experience. So this graphic quite aptly demonstrates the development of things at our side, at least. Prior to 2015, we saw a relatively small volume of claims involving data protection breaches each year, but it then started to pick up slightly and steadily from there. Volume started to ramp up in 2019, then doubled in 2020 and doubled again in 2021. Volumes have dropped slightly each year since then, and Beth will explain some of the reasons for that when we get to her section, but we do expect the sort of volumes to level off soon, and it will remain a claim type that features prominently for most of our customer base. Now, this is only Zurich's own experience, but based on what we hear from other sources, other compensators and insurers are seeing similar trends, particularly in the public authority space. For example, the NHS, where large volumes of personal data are held by organisations. From a risk perspective, the more data you hold, the higher the risk is. But every organisation holds data now, so there's no organisation that's really immune from claims in this regard. So Beth will explain in due course why the volumes have slightly started to tick down in more recent years, but why did they spike to begin with? It's actually due to a variety of reasons, which I'll just try and cover as quickly as possible. The first and most important factor, although it's quite complicated, so bear with me, was the Court of Appeal decision in Vidal Hall versus Google, which was 2015, so 10 years ago now. That case concerned the conduct of Google, who were collecting private information about the claimant's internet usage through their Safari internet browser without prior consent. As a result, Google and other technology companies were in breach of the data protection legislation by doing that, and they received substantial fines as a result. The crucial point to come out of the civil case against Google was that the Data Protection Act 1998, or DPA for short, was incompatible with the overriding EU legislation. As I said, it's pretty complicated, but the EU directive was to be embedded into local law within EU territories, and the UK done that through the introduction of the DPA. Under Section 13 of the DPA, the claimant was required to demonstrate damage as a result of any data breach in order to secure compensation. And damage had largely been accepted by the UK courts to mean bodily injury, so a recognised psychiatric injury or financial loss. And on a practical level, this meant that very few cases met the required threshold, and claim volumes were very low as a result. The high threshold was no doubt deliberate on the part of the UK Parliament when enacting the 1998 Act, in order to avoid large volumes of claims and a strain on the public purse in particular, given what I said about the NHS and local authorities, etc. However, under the EU, the overriding EU legislation, there is no requirement for the claimant to have suffered damage. To be entitled to compensation, a claimant merely needs to demonstrate that they have suffered distress as a result of a breach, and this is a much lower threshold than demonstrating a personal injury. And as a result, it's extremely difficult to refute from a defendant's perspective because there's usually no medical evidence produced when it's merely a claim for distress. So it's now substantially easier to recover damages in the case of a data breach, hence why it has recently, in recent years, become open season for claimants. The only surprise from our perspective was how long it took claimant firms to recognise this opportunity, which has only properly been targeted in more recent years. But as I'll explain shortly, it's probably because they had their attentions were elsewhere. The other reasons, around the time of the spike, 2018, the GDPR, or General Data Protection Regulation, was brought in, and what followed that was the UK enactment of that in the form of the Data Protection Act 2018. So at that point in time, there was quite a lot of public awareness around data, people's rights around their data, etc. So that heightened the issue a wee bit. And then from a claimant firm perspective, there's a few factors that have played into this. It has been referenced, data breach as a claim type has been referenced by some commentators in recent years as the next whiplash. And with the benefit of hindsight, that's quite a dramatic take on the issue. But the similarity between the claim types is the involvement of the claimant representative community and claims management companies in particular. Claimant firms are in the main very sophisticated, and they're always looking for their next revenue stream. They're under more pressure to do that these days than they've ever been for a variety of reasons, including fixed recoverable costs, which have been in place on standard personal injury claims in England and Wales at least since 2013. And that removes substantial income from claimant firms in the process. Fixed recoverable costs and a very strict pre-action protocol have been in place on holiday sickness claims since April 2019. And again, the similarities between holiday sickness and data breach are quite telling. This was one of the areas targeted first after the squeeze on general personal injury claims in 2013. The travel industry was hit very badly by a surge in claims a few years back, with a 500% rise in gastric illness claims between 2013 and 2016, all while reports of food poisoning at holiday resorts remained broadly flat. This, at least at the start, was driven by a bit of a commercial approach by holiday travel companies looking to manage customer relations and avoid adverse PR. So there was an initially approach to just settle claims without thoroughly investigating them and seeking robust medical evidence, etc. But that only really made matters worse and generated more claims at the other end. Eventually, ABTA, who are the travel industry body, and the companies all came together and fought back against this. And they now appear to have solved the problem in the main through the introduction of a very robust pre-action protocol, but no doubt the cost of that surge has been passed on to the average UK holidaymaker, and this was very much a UK issue at the time. Next is PPI, which I'm sure we're all glad to see the back of, but the deadline for that was August 2019. Thinking back to the previous graph, 2019 is the year where volumes really started to ramp up, and it's probably no coincidence that it's the year that the PPI and holiday sickness gravy train was brought to a bit of a halt. We obviously had the pandemic, which resulted in a reduction in road traffic accidents, which is a bread and butter type of claim for claimant firms, which would have perhaps pushed them into other areas. Second to last point is the ongoing economic pressure, which was brought about by the pandemic, and we now have the cost of living crisis. So it may just be as simple as there's certain people out there that wouldn't previously have brought a claim, but are now bringing a claim for what are relatively trivial matters in the main. And the final point links back to the holiday sickness discussion, but it's a commercial approach taken by compensators. Certainly when we go back 10 years, when Zurich were seeing very low volumes of claims, we would take an economic approach to these types of cases with the point of view that it's cheaper to pay them at an early stage than potentially run it to trial. But at the point at which we were being confronted with real volume in this area, we started to develop robust strategies on quantum, costs, etc., and just claimant behaviours in general, and that has helped us get a proper grasp of it, and is probably, although we've not got any real data to sort of put around this as yet, we think that has really started to bear fruit in recent years, and that is part of the reason that volumes are starting to drop down again. So, and I think the market in general is starting to come together on that as well. So that's good to see. But Beth will explain a bit more about the background to that in due course. Just a quick slide again, just to build on the claimant market point. As I said a few years ago, this was a claim type that was being referred to as the next whiplash, and some people were also referring to it as the next PPI. That was definitely overplaying it because the volumes never got close to that sort of level. But the common theme is the types of firms involved. A simple Google search, as shown on the left-hand side here, brings up pages and pages of claimant firms touting for business. On the right-hand side are examples of advertising that we've seen over the years, including social media posts, radio advertising, and red top articles from The Sun, etc. I borrowed this slide from a previous presentation that we did a couple of years ago on this topic, but when I looked for more recent content, the aggressive advertising that had become a feature maybe 3 or 4 years ago now appears to have gone quite quiet. Again, Beth will cover off some of the reasons for that, but it may just be that the brakes have been applied on the gravy train in recent years through insurer strategies. A couple of final slides from me before I hand over to Beth, just touching on policy cover. The reason I wanted to talk about this was that in recent years we've seen a number of policyholders report claims to us quite late in the day, after a point at which significant costs have been built up on both sides, the claimant side and sometimes where they've got their own solicitors instructed. Now that can obviously create potential late notification issues, but the main problem is the cost issue, and sometimes a customer's own solicitors can rack up costs unnecessarily on what is a relatively straightforward type of claim if they're dealt with properly. Our public authority customer base that receive high volumes of these cases are now very well educated on how policy cover operates, but other customers that do not receive cases very often are not always aware that cover exists for such claims. As they are not always presented as personal injury claims, it can throw customers off at times. So the excerpt that I'm showing here on the slide is from our standard policy wording, just a health warning. Obviously, the terms and limits will differ from customer to customer depending on the policy that they've got with us or any other insurer. But I simply want to make it put across the main points of it. Cover is generally provided under the public liability policy. They can sometimes be presented as personal injury claims, though it's rare. If they were presented as a personal injury claim, they would be dealt with just as a normal PL claim under Section A of the policy, so accidental personal injury, which I've underlined there. However, because of the Vidal Hall versus Google case, which I mentioned earlier on, most claims are now being presented as claims for distress only, meaning that Section A does not trigger. Section C, which I've also underlined, covers a range of more unusual causes of action, including invasion of privacy. But that in itself excludes liability under the DPA or GDPR. However, whilst it's excluded there, it's written back in under a separate extension, which I'm just going to bring up. So the pertinent points rather are underlined here. In short, there is a liability. The liability to pay damages for any breach of the DPA or GDPR is covered. As you'll see at the bottom, this is subject to a limit of indemnity of £1 million under £1 million under our standard policies, which is in the aggregate and cost inclusive as well. There are a few exclusions within this cover too, excluding the cost of replacing, reinstating data, etc. These are elements which may be subject to cover under a cyber policy, but in short, the wording is designed to provide cover for third-party data breach claims, regardless of how they arise. Beth will explain what we mean by the term silent cyber when we get to her section of the presentation very shortly. And as I said at the start of the previous slide, this is our standard policy wording. Some customer cover appears on different sections of the policy and may be subject to different limits and excesses, etc. But this was just to, I guess, make the general point around policy cover. So at this point, I will now hand over to Beth, who will talk you through some of the claims handling strategies and the issues which arise. Beth.
Thanks, Stephen, and good morning, everyone. I imagine that at some point, some of us or all of us would have had some message to say that their email or their details have been sent or disclosed to somebody, whether that be generically or just a simple communication to say that they're investigating an issue. As evident from this slide, and as most of you are probably familiar with your obligations under the GDPR, this slide provides a reminder of the key principles set out by the GDPR and the rights an individual has in respect of their data. The key message to take from this slide is that any personal or special category data that you deal with should be processed lawfully, be necessary or relevant to the matter at hand, and should be dealt with consent. The next slide that we'll look at relates to the data processor via data controller. We'll now explore the difference between each of these. The data processor processes personal data on behalf of the controller, whereas a data controller is an individual or public authority which determines the purposes of processing of personal data. A processor may be liable for any incidents that arise whilst they are dealing with data on behalf of the controller. As an example, you may outsource a specific part of your business to another company who provide a particular service such as debt collection. As part of this agreement, you share data belonging to individuals with the outsourced company, such as contact details for the purposes of collecting the debt. The outsourced company takes a call from an individual and discloses inaccurate information to a third party by mistake. As the data controller, you provided correct and accurate details, and therefore the data processor is likely to be responsible. As with any claim, it is each case on its own merits. There does tend to be contracts in place between the parties, which sets out the obligations each firm has under the contract, and on some occasions, this sets out who the data controller or the processor will be in the event of a claim. As Stephen touched upon earlier, the next slide relates to silent cyber. We are seeing more and more cyber attacks occurring. Firstly, because the preferred method of communication is email, and secondly, because most data is stored electronically. For an example, an individual could gain access to your systems following a suspicious link being sent to an employee, or a cyber criminal is able to gain access to your network by hacking. Any costs associated with the rectification of your network is not covered, and this would be best placed with your cyber insurers. Referring to Stephen's earlier reference to policy cover, we would not be liable for any reinstatement or rectification of your data following a cyber attack. The objective of the cover under the policy is to provide what's called silent cyber, which specifically relates to any third-party claims we receive resulting from any cyber attack. As mentioned in the previous slide, and as a reminder, a data processor can be responsible for any claims received as the cyber criminal has accessed their network and not yours. They would be the processor of your data and would likely have their own data protection policies and procedures in place. This would, of course, depend on the terms of any contract you may have with the individual or firm, as they may be incorporated into your business rather than being an entirely separate organisation. We would take this opportunity to emphasise the importance of ensuring that you have sufficient security measures in place and that data protection training is provided to all employees. The next slide that we will now refer to is the standard letter of claim. This is what we tend to see within the specialist claims team. So what is a standard letter of claim? As you'd expect, our teams see a wide variety of claim types, some straightforward and others more complex. There are a few common categories which I will briefly mention here, starting from the minor claims and moving up to the more serious. The first example, an email has been CC'd to recipients rather than blind copied in, meaning that everyone on the distribution list has seen each other's email addresses, and from that, it may be possible to work out people's names. As you could imagine, the distress is likely to cause minimal impact to the individuals concerned. The second example relates to a letter being sent to an incorrect address. For example, a letter was sent to number 6 instead of number 8. The content of the letter is central as to the level of distress this may cause, as well as whether the letter was opened by the incorrect recipient or not. We have seen low-level examples such as a letter from a GP confirming an appointment date and time, which provides very little personal information, to more serious letters relating to social services involvement with a looked after child and their family. The latter is far more serious and understandably cause a higher level of distress than the former. As you would expect of situations like this, the incorrect recipient does not always keep the information to themselves, and this may be shared within a particular community or on social media. The third example relates to social services files. We have seen examples where social services files have been left in an office unsecured, or have sadly been left at the home of a family where a social worker was moving from home to home on a day-to-day basis. As referenced above, a social care file is likely to contain confidential and sensitive information relating to an individual, which, if read and shared with other third parties, would understandably cause distress. The fourth example relates to an address being shared with the birth parents or of an ex-partner. This is usually the most problematic type of case we see. For example, an adopted child whose birth parents are not legally allowed to have access to them, and the adoptive parent's address is shared with the birth parents, or a victim of domestic abuse's new address has been shared with their abusive ex-partner. Clearly, this would cause significant distress, and in some cases, a claimant has been required to move properties to avoid any issues. The costs of any relocation are recoverable, as well as damages. The final example on this slide relates to the records being scanned onto another person's file. As mentioned, we have seen scenarios where a patient's NHS letter from a hospital has been sent to their GP, and this has unfortunately been scanned onto another patient's record by mistake. This record becomes visible to the other patient, and this letter contains confidential details surrounding a medical diagnosis. As always, it does depend on the contents of the letter, but if it does relate to the diagnosis of a medical condition, this is likely to cause distress. And we'll now turn to the allegations made. So with factual scenarios such as that, what are the allegations that are put forward? Well, claimant representatives tend to throw everything at it within the letter of claim. The obvious one is breaches of the GDPR and the Data Protection Act. In reality, this is what the main and only cause of action should be on most claims. However, in an attempt to complicate matters with a view to seeking higher recoverable costs and HE insurance premiums, claimant firms also include other causes of action such as misuse of private information, breach of confidence, breach of Article 8 under the Human Rights Act, which deals with the right to privacy. In practical terms, how the claim is pursued makes very little difference to how the claim is dealt with. The other causes of action may be relevant in some cases, but at the heart of them is usually a straightforward data breach, and damages are assessed on that basis. In the case of misuse of private information and breach of confidence, they require deliberate, wrongful conduct and are normally added in as a basis of recovering the HE premium. As we know, most of these incidents tend to arise as a result of human error only. In relation to Article 8, the claimant must persuade a court that there has been an infringement of their rights, and as there are alternative remedies available to them under the GDPR or the DPA, a compensation payment pursuant to the Human Rights Act would not afford them just satisfaction. We will now turn to liability. Whilst there may be an obvious breach, this does not necessarily mean damages are awarded. A technical breach is when we admit that a breach has occurred. but we either 1. Deny liability on the basis the breach was so trivial that no damages are awarded. 2. Deny the breach has caused the loss as alleged and the claimant is put to strict proof. Or 3. Damages are awarded as it crosses the threshold of seriousness. The burden of proof is on the claimant to prove that actual harm has been caused beyond initial shock, and the claimant must provide evidence to support any loss over de minimis. For those of you who are not familiar with the term de minimis, this is a legal term that states any breach which is not considered to be serious enough by the courts would result in no damages being awarded to a claimant, and we regularly use de minimis arguments in response to a claim. As mentioned earlier, if the breach is so trivial in nature, such as an individual's name, this is likely not to cross a threshold for damages, and it would be de minimis. We do get incidents where an employee has accessed an individual's file to obtain information about that person on behalf of someone else or purely for their own gain. An employee tends to access any records as they are emotionally driven by such a decision. However, they are acting outside of the course of their employment and had no real reason for accessing these records as part of their role. As the employee is gone on a frolic of their own, we can defend these cases as per Ali v Luton and W.N. Morrison Supermarkets v various claimants when it comes to vicarious liability. We'll now turn to the next slide, which relates to verbal disclosure. On occasion, we do have circumstances where an individual has disclosed information about another, whether that be over the phone, whilst in a meeting, or within a reception area. Any verbal disclosure is not considered to be processing of personal information under the Data Protection Act, as per Scott v LGBT Foundation. However, this does depend on what data was disclosed and in what setting. As with any claim, it is each case on its own merits. However, if special category data relating to an individual's medical condition was discussed within an open plan office and other employees or patients were not aware of this information, this is confidential data and any claim would likely fall outside of the above. The claim on this occasion would likely be pursued as a breach of confidentiality and a misuse of private information rather than a breach under the GDPR or the Data Protection Act, as no data has been processed. So, the next slide is quantum. So how much are these claims worth? That is unfortunately not an easy question to answer, as there is a lack of guidance from the courts on quantum. As damages are payable for any distress suffered, valuing how much a claim is worth is very subjective, unlike a personal injury claim, which will be assessed by a medical expert and an opinion will be provided on the scale and severity of the injury sustained. In the case of a data breach distress claim, you are only given the claimant's word for how distressed they were, which is open to exaggeration, particularly when it is difficult to disprove. You need to put yourself in the claimant's shoes and consider how distressed an ordinary individual would be by the situation. However, this isn't always ideal, as different people react differently to certain situations. However, judgment calls need to be made, and the relevant factors to consider are the nature and the content of material, which in the case of the letters mentioned earlier will be different in each case. Is there special category data involved, such as the health or religious views of an individual? The more sensitive and personal, the higher the level of distress awards. Disclosure itself, how many people and who, is a very important point. One-off event or something arising from poor processes and procedures. What efforts have been made to retrieve or delete the data shared, and how successful has that been? And the final point to consider is the actual impact on the claimant. Most cases are entirely subjective, but in some cases, evidence is provided to back up the allegations. For example, the claimant attending their GP with anxiety issues following any disclosure. I just want to briefly touch on some of the cases which provide guidance and which are evident on the slide. The first case is Galati v Mirror Group News. This concerned the high-profile phone hacking scandal, which involved a number of celebrities. Damages in this case range from £85,000 to £260,250. It is not really applicable to the types of cases we see, as this involved deliberate, malicious, and invasive breaches of privacy. However, as you would expect, this is frequently quoted in correspondence from claimant representatives as a rationale for seeking higher awards of damages. The second case relates to TLTV Home Office. This is probably the most helpful case we have to work with at the moment. The case concerned the Home Office's publication of quarterly statistics about the family returns process, the means by which those with children who have no right to remain in the UK are returned to their children's country of origin. The information was available for approximately 2 weeks before being taken down, by which time 20 different IP addresses from around the world accessed the information. The claimants were fearful of consequences of disclosure and in some particular fearful of intervention by the government of the countries they had fled. Damages on this occasion ranged from 2,500 to 12,500 per person. As I said, this is the most useful case we have to work with at present. There is almost a starting point at 2,500 for cases where claimants are, from our perspective, reasonably distressed by a situation. And as the higher awards involved cases where the claimants were fearful for their lives, it sets a ceiling at 12,500. The difficulty with a lot of the clearly genuine distress cases that we see is that it's very difficult to assess where some cases sit within the 2,500 to 12,500 bracket, and it really just comes down to a personal judgment and experience most of the time. More recently, we've had the case of Driver v Crown Prosecution Service, where a very low award of £250 was made. The case concerned unlawful sharing of information by the CPS to a political opponent of the claimant. The judge did not find the claimant's evidence of distress compelling and stated, and I quote from the slide, "I consider that this data breach was at the lowest end of the spectrum." This leads us on to the next slide, which relates about de minimis. So an issue which hasn't really addressed by the courts is whether there is a threshold for securing damages, as there are some cases that are so trivial with only minor details shared that surely do not merit damages. We are at present closely considering some cases like this and will ultimately look to push the correct cases into litigation to try and seek the court's views on it. However, another case involving Google, Lloyd, provides some potential comfort around this. A key quote from it is on the screen. We would emphasise the points surrounding de minimis and the threshold of seriousness being met for a one-off data breach claim which was quickly remedied. In the case of Rolf, a statement of accounts relating to school fees was sent to the incorrect recipient. The claim was unsuccessful with the courts, emphasising that a claimant must have suffered actual damage and that a claim cannot succeed where any possible distress is trivial. We routinely see one-off type claims, a completely accidental error by an employee which is very quickly remedied and not deliberate. Arguably, no harm has been caused. The most recent case is Farley v Equenti, which confirmed that if a claimant could not provide evidence that a letter had been opened and read by a third party, they would have no viable claim for misuse or data protection. The judge confirmed this was a near miss only, even if it caused significant distress. We would highlight that this case is currently being appealed in the courts. We hope to have some clear guidance from the courts in the future on this issue. However, the Lloyd case was heard by the Supreme Court, and whilst the case concerns a number of different issues regarding privacy, we are hoping that it provides some guidance on the de minimis threshold. If guidance is provided from the Supreme Court, this is binding on all lower courts, so it could be extremely important. However, they may let county courts consider these matters. We now head on to our final slide, which relates to costs. As evident from our presentation, it is pretty easy for claimants to pursue these types of claims, and as the issues on costs is an untested area of law, this is a profitable business for claimant firms. As noted on the slides, costs can be claimed at up to 10,000 times the level of damages claimed. Strictly speaking, claims should be handled under the pre-action protocol for media and communications and heard by the High Court. However, this protocol and claim track was designed for Galati type cases mentioned earlier and high profile defamation claims. The loophole being exploited with claimant firms is that high cost costs apply. We tend to advise solicitors that the pre-action protocol for media and communications does not tend to apply as per Civil Procedure Rules 53.1. The cases we see are unlikely to be considered in a high court. We regularly see solicitors argue that standard costs apply on these cases, regardless of the value. We do try to argue these cases are suitable for allocation to the small claims track. As Stephen mentioned earlier, we have had success in arguing allocation to the county court and small claims track, meaning that only nominal costs are recoverable, if any. This is supported by the case law evident on the slide. Claimant firms always seek to adapt to these developments and to avoid the small claims track point. They obtain medical evidence to pursue a personal injury claim. From personal experience, the medical evidence rarely supports a recognised psychiatric injury as being attributable to the incident, or it simply does not add value. We challenge these accordingly and if necessary. If an injury claim is pursued, we try and argue that fixed recoverable costs for a personal injury claim apply, as this is technically an accidental, one-off event giving rise to an injury. This, as evident above, is an untested area of law. In terms of how Zurich and the market generally target this problem, it is unclear what the best solution is. Under the extensions to fixed recoverable costs, data breach claims are being captured, and the argument is, from the solicitors mainly, that they should sit under band 3 of the intermediary track. However, the rules are complex and open to manipulation, and we expect that firms will find a way to force them out of the process by raising mixed allegations, as referenced previously. Time will tell in terms of how this plays out, and we are currently working on strategies to tackle the challenges ahead. This now concludes our presentation, and we hope that you found it useful. We will welcome any feedback or questions you may have, and I will now pass this over to Lisa for Q&As.
Hi again, everyone. So thank you very much to Steve and Beth for a really informative and interesting session. Just before we go to the Q&A, as we mentioned before and Beth just touched on it, we would really appreciate any feedback. So you should be able to see on the screen the QR code. If you could just take a few minutes after the event, so if you could just scan the QR code now, it's just a few simple steps and then to submit it back in. Also, Becky is going to add to the chat a link if that's the way you prefer to access the question, so that would be really appreciated. We have a few questions in on the chat. So the first one is, if the name, telephone number and the email addresses are disclosed, would that fall into the de minimis? Not sure who wants to take that, Beth or Steve?
Yeah, I'll take that. So yeah, we have defended on the grounds of de minimis. The particular reference in the de minimis slide is the Underwood v Bounty file, where it actually relates to the date of birth, gender, the name and contact details of an individual. And we have been able to defend on de minimis on those grounds. It obviously depends on who it goes to, but normally we have been successfully in defending those matters.
Perfect. Thank you, Beth. Okay, moving on to the next question. So the GDPR focus on harm to the individual, how is this factored into the claim defence?
I've put in some answers to the questions already on the chat. Thankfully, Beth's answer to the last question was the same as mine, which is good. In response to this question, I think it'll come back. Some of the stuff that Beth covered off in her slides, it really depends on the harm that's been caused. So the claimant needs to demonstrate that they've suffered harm to be able to recover damages. There may well be a technical breach of the GDPR or DPA, but that doesn't always translate to a payment of damages. So they still need to basically demonstrate that they've suffered some harm. But as we discussed, that is difficult to sometimes disprove. But yeah, each case in its own merits, I guess, to use that old analogy.
Perfect. Thank you, Steve. I didn't realise you were already on it and answering the questions for us, so that's really great. I think, unless I've missed one, oh, there's another one in the chat. Would the Farley case also apply if we cannot evidence that an email was not opened?
So it would fall back on the claimant again to prove that that individual has opened that email or read the email. Sometimes you normally get straight contact from that individual to say, I don't think that was for me. And then they'll normally make arrangements to get that deleted. On the other front, it still would need to be proved that it depends, again, on the nature of the email. If the email was just simply saying, this is a tax reminder due for the 2025 calendar year, then obviously that is going to be de minimis. If it contained a confidential report relating to a Section 47 child report, then that obviously is different. It just depends on the nature, but we try and deny them depending on the contents of the email that was shared.
Yeah, I would just add to that. I think it maybe be more difficult to take that line on the case of an email, because in the case of a letter, obviously you'll see it coming through your letterbox and recognise quite quickly it's not for you, and you probably shouldn't open it. But in the case of an email, you don't realise it's not for you until you've opened it. So yeah, again, it will come down to the actual what is the content of the email, how sensitive is the data, etc., etc.
Okay, perfect. Okay, I'm trying, apologies if the questions aren't being asked in order and some of them may overlap. So we've got one in, it's asked, if a letter is sent out by error, sometimes the recipient has refused to destroy or return it, how would this impact the breach claim?
So it all firstly would depend on the contents of the letter, because as I've said, if it just doesn't contain a lot of personal information, then the impact would be minimal. If obviously the individual's concerned, so there's two ways you can go about it. If the letter's been addressed to the correct recipient, but the address is incorrect, then you've got the Postal Act, which says that they shouldn't be opening anybody else's post. And obviously we can then say, well, you shouldn't have been opening that post. And obviously if any issues arise later down the line, we could actually bring you in as a defendant potentially. The other we've never done that before, but it is an argument that we have started to see. The other aspect is that obviously if it hasn't been retrieved, you've done all that you could to retrieve that data, you've contacted the person, it obviously will it all comes down to the contents, unfortunately, what is in the contents of that letter. But if you've tried to make attempts to contact that person, it still would then fall back on the claimant to prove that that has had a severe impact on them personally. Unless Stephen's got anything further to add to that.
No, I think that's a great answer, Beth. Thank you.
Okay, thanks, Beth. Okay, another question. How does the regulator's response to a data breach report and or complaint from the data subject impact on claims?
I'll take that one, Beth, if you want. Yeah, it's probably it's very important. In a lot of cases, we are able to use the ICO's response to a customer organisations have got obligations to report breaches and things like that. If the ICO comes back and says, like, thanks for letting us know, but we're not going to take any action, then that gives us a fair bit of confidence that we can raise the de minimis arguments and try and defend the claim. However, if they obviously come back and say you need to take these steps and take it quite seriously, and they can sometimes go down the line of fining organisations, then obviously that is going to have a massive impact on liability, and the likelihood is that in such scenarios there'll be a payment required at some stage. Hopefully that answers that question.
Thank you, Steve. So another one's in, would you expect organisations to offer what they consider a proportionate resolution as part of the breach investigation prior to becoming a claim?
I think that's quite closely linked to the previous question.
Right,
I guess
okay.
that would be no, it's another good question. But I guess it would come down to the organisation's approach to these things generally, and with customer relations and PR in mind, they might want to offer compensation through their complaints process or something like that. Ultimately, Zurich as the insurer would just ask that they deal with things reasonably and pragmatically. They don't necessarily need to offer any compensation or go beyond that. When a claim is if a claim is intimated at a later stage, then we'll just deal with that on its own merits, regardless of what's happened before. Obviously, the usual thing around any sort of claim type is just don't make any admissions of liability, but it's okay to make apologies and do whatever the organisation needs to do under their normal processes.
Perfect. Thanks, Steve. If the client has a cyber policy and a commercial combined policy, should we inform the liability insurers as well?
I would say yes. Just out of a pure abundance of caution, I think it's always reasonable to notify any insurer that where cover may arise. There may well be a crossover in terms of the cover that's applicable. So I understand we are not experts. Me and Beth aren't necessarily experts on cyber policies. We've got a separate team that deals with that, but my understanding is that there is cover for third-party claims under cyber policies as well, plus all the additional cover for rectification and things like that, and just general response to a cyber incident. So it may be that the liability insurer and the cyber insurer work together and proportionately deal with the claims that may be on a 50-50 basis or something different depending on the terms of the policy. But yeah, to answer the question in simple terms, both insurers should be notified if the cover is held there, because again there might be a difference in excess as well between the policies. So yeah, just a lot to be factored into that.
Okay, thank you. Really good that we're having a lot of questions coming in. So we've got another one. Are breaches of timescales for responding to SARs, etc., the same threshold for damages as data breaches, i.e., only need to show distress in order to for compensation? Bear with me, let me finish that. To be paid. And is this something covered under the policy or through complaints?
So yes, is the answer. It does tend to fall. We have seen a lot of cases that come in where an individual submitted a claim for a failure to respond to a SAR request within the 1 calendar month. Most of the cases we have defended on the grounds of de minimis because the information that we've tend to seen, some of them have requested data about what a firm holds about them or what they've previously paid on tax in the previous years. The most significant serious matters where the threshold for de minimis is likely going to be crossed is if it relates to like the loss of a social care file. So it's just to sort of, we have handled them before. So yes, they do fall within the perimeters of distress, and they also have seen them where they've evident of potentially crossed over into an injury element because of the anxiety it's caused that person. So in answer to the question, yes.
Okay, thanks, Beth. Okay, we've got another one. Can you provide wording which can be sent to an email recipient with whom the letter information was accidentally shared with? Wording which would encourage them to delete information accidentally shared.
I can take that away with Stephen and we can try and do something if unless Stephen has any objections, but yes.
That's fine.
We can look into that then. Thank you. And another one, how should we deal with an incident whereby one customer is contacting others following an email being sent to a group without being blind copied?
Yeah, that's a difficult one because at that point you've sort of already lost control. Linked to the previous question, all you can do is say that apologies, you were sent this in error, please delete and don't pass on to anyone else. But certain members of the public will just go off in a frolic of their own, to use that terminology. That scenario itself is actually covered as was the circumstances of one of the claims that was on one of Beth's last slides, the Guiamphe versus Bristol City Council case, which was a Zurich case, which we defended on the grounds of de minimis. That was quite simply a case where an email was sent out. I can't remember exactly what the details of the email were, but they were it was relatively innocuous, and the recipients were copied into the email rather than blind copied, so they all seen each other's email addresses, and that was basically the basis of the claim, that was a breach and they were distressed by it. The court gave that argument quite short shrift on the basis that it's just an email address that is very trivial, and as a result, there's no compensation. You're getting no compensation for it. But if they do start all contacting each other and maybe harassing each other, then that's sort of outside the organisation's control at that point. That may be a factor in terms of what happens with the claim, but we would probably be looking to take the argument that that's not our we've caused the situation, but what happens after that is not really our fault or responsibility. But again, yeah, we would need to look at that very carefully.
Yeah, okay, thanks, Steve. Another question, we used to offer a subscription to fraud alert monitoring along with an apology when data breach occurred. Is this okay? Or could this affect my future claim if we've offered compensation already?
I think we would say, and the second part of that question, we would say that maybe we may be able to take that off of any compensation award that is made at a later stage, but probably not. But if a payment was made under a complaints process, then that wouldn't necessarily prejudice the position under the policy. The subscription to services like Experian and things like that, I know that seems to be a standard approach that larger organisations take when they've been the victim of a cyber attack. Usually consultants are involved to advise them on. Consultants or legal panel are involved to consult them on that, and that'll be one of the recommendations, because that'll then reduce they'll then know if their data is appearing on the dark web and things like that. So it's a good way of potentially mitigating the damage and I guess managing the customer and the PR issues that come with that. So it seems to be a course of action that's recommended. So yeah, there's nothing wrong with doing that. it obviously comes with a cost, and that may be covered under cyber policies, but I can't confirm. That would depend on the scope of the cover.
Yeah, the individual, yeah. Okay, and I'm not sure if this one is similar. So can organisations offer a gesture of goodwill for inconvenience caused for a minor breach, or is this a complete no?
Yeah, similar to a couple of the previous questions. Yeah,
Yeah.
organisation can do what they can proceed as they see fit. But it wouldn't necessarily, the fact that a payment has been made wouldn't necessarily stop us when it gets to the point of a civil claim from defending the claim on de minimis grounds, because that's an internal pre-claim process, I guess.
Yeah, and yeah, we do have quite a few similar ones. Someone has asked, you say do not admit liability in offer of compensation. So line is just for sorry for your distress, and this offer is in full and final statement, etc. Would that wording work?
We normally say that it's just that it's probably more like so we don't, where if you admit that as a breach occurred is fine. I think it's when it comes to you apologise for the distress. You don't want to say I apologise, this has caused you distress. We normally say I apologise that if this may have caused you distress, just so we can sort of say that if it comes in a claim, we haven't got outright admitted that there is distress, because that would be where the claim would sit best. I don't know if Stephen has any further views on that, but I just think it's the wording in the bottom of the letter that's probably the most important bit.
Yeah, I think acknowledging that there has been distress probably potentially prejudices any ability to defend the claim on the minimis grounds at a later stage. Ultimately, if you want to sort a claim out before it's notified to insurers, just to try and draw a line under it, then as long as both parties agree to it in writing, then that'll draw a line under it. The wording of how that's worded is largely irrelevant, as long as there's agreement on both sides that we can hold them to at a later stage if they then try and bring a claim at a later point. Okay,
thank you. Okay, I think I've covered all of the questions in the chat. If I haven't, and I'll go through them after the session, I will pop them in the when we send the link out to everybody. We'll answer it and then pop it in the email then, so it's answered. Because I think I've covered everything.
I think there is another. I think because there's some been put in the Q&A and a couple have been put in the chat as well. I don't know whether you want me to just cover.
Yeah, if you can see, happy for you to read it out.
There's one question in the chat about if a council tax final notice or court summons goes to the last loan address as per the law. If this was opened by a new property owner or tenant, would that be a breach?
So it would be considered as a technical breach because it's been sent to an address, but there's two scenarios I would say to that. Number one is if you were aware that they've changed address, and number two, we have defended them previously because the tax information doesn't tend to contain a lot of special category data. It does contain some personal information about a name and a tax number, but obviously if they're no longer at their address, there's no other information that's being contained within that. So we have been able to defend those on de minimis. And yeah, I haven't seen any that we've actually been able to admit liability on. So, yes.
There's another one saying, what if a letter is accidentally included with another letter?
I think it just it all goes down to the contents of the letter. So if it's just a simple reminder, like the tax reminder, and it's gone to multiple different people, which we have seen before, it obviously doesn't contain a lot of special category data. If it relates to a more serious sort of looked after child report, which was sent to somebody that had no entitlement to see that report, then obviously that is more of an issue than what was previously suggested. So
any more, Becky?
There's one more. I'm just sorry. Some people I think have put them in the Q&A afterwards, realising. So I'm just trying to check that. Okay. Someone's put, I have previously sent the incorrect email recipient a request to delete or delete from deleted items the email, and also advised that if the email has been read that no actions are taken, with any of the information. We ask for response to advise they have understood this. This, of course, does rely on the recipient, but any thus far have been very happy to advise not read and deleted. This would help in some way for a claim, but obviously still dependent on the information. And if so, how would we be affected? Would we still report it internally as a breach?
So I think if you've got confirmation from that person, so say that the email was sent at 13:05 and you got an email, you realised, and at 13:10 you said, can you delete the email? The person came back to you and said, email's been deleted, it's not been read. We can actually use that in an argument to say the person's had been receipt of this information for 10 minutes, it's not being viewed, and it's been deleted, and we actually can use that in any sort of, whether it's to make an offer, depending on the contents, or whether it's actually just a deny liability, we can say it wouldn't have been reasonable to have that. So you still need to report it because it depends on what the nature of the information was contained in it. So I would still report it internally, following your own internal processes if you need to, and then you can make the decision as to whether you need to report to the ICO from there or not.
Thanks, Beck. I think that's it, looking at all of them.
Becky, there was just one final point or question, very quick question. I just noticed when I was scanning through the messages, what's the sort of defence rate on these cases? We probably don't, our data isn't mature enough to answer that 100% accurately, but based on what I've seen in recent times, looking through Beth's caseload, for example, it's probably around 50%, if not higher. It really depends on the types of claims we're seeing, obviously, but there was a period there where we were seeing a lot of trivial claims for really low level stuff, and we were defending them quite robustly. As claimant solicitors get the message that we're not going to roll over and pay on those claims, that will probably over time start to reduce the claims, and then the claims that are put forward will have a bit more credibility to them. So the defence percentages will probably shift with the sort of strategies that we're adopting overall. But yeah, all I'd say is that we've got a really strong handle on it just now, and are taking consistent approaches across our portfolio of claims, and also adopting different strategies for different claimant firms depending on who we're dealing with. Beth's got to know them, quite a lot of them, very well in recent times. So yeah, hopefully that answers that question okay.
Thank you very much again to Beth and Steve for a really useful session. And thank you to everyone who's joined, and also all of the good questions that have come in. Really, really good. As I've said, we'll send out the recording once the link is ready. And if you could take some time at the end of the session just to fill out the feedback for us, that would be amazing. Okay, thank you very much, everyone, and enjoy the rest of your day. Thanks, bye.